anyone remember the episode of Sex and the City when Trey and Charlotte are registering for wedding gifts and he sneaks in a prenuptial agreement for her to sign with some other paperwork? When Charlotte realizes what it is, she freaks out and interprets that Trey is already anticipating a divorce. That used to be the perception surrounding prenups, but not anymore. In fact, prenups have become quite the norm and a common practice among couples. According to the latest data, half of U.S. adults say they're open to signing a prenup, which is a legal document both sides sign before saying I do, and it ensures what you came into the marriage with will stay yours in the event of a divorce. Joining us to explain why prenups have become chic is Sean Smith, a member and co-founder of the family law department at the New Jersey law firm of Brach Eichler. In addition to his fierce litigation skills, Sean also works with the New Jersey courts as a mediator, where he helps parties in a divorce come to an agreement on complex issues. Sean, welcome.
Well, thank you very much for having me. Always a pleasure.
Always a pleasure to have you. And as we just said, the pendulum has shifted when it comes to discussing prenuptial agreements. When did you start seeing this shift, and why has it become a common practice?
Oh, it's a great question. It's funny you mentioned the Sex and the City episode, because that was at the beginning of my law practice. That was right around the year of 2000. And at that point in time, prenuptial agreements were very often considered unromantic, mistrustful, taboo, and negotiations relating to them were tended to be very adversarial. And a prenuptial agreement is an agreement that you're entering into before you're getting into marriage. It's difficult to go into a marriage when you started the marriage on an adversarial sort of footing. Today, I would say that they've increasingly been used more from a financial planning instrument, and that change really started around the time that baby boomers and the significant wealth transfer that's undergoing right now started. Figure 10 or so years ago. And there's several reasons for the shift. One is a sort of a business-like mindset that has developed with modern couples who approach marriage with the same pragmatism that they bring to business partnerships. And that prenuptial agreements once were looked at as relationship agreements, they're now more about contracts designed to clarify expectations, provide individual assets that individuals are bringing into marriage, reduce future disputes, almost as a tool designed to avoid any long-term legal battles. And a lot of this is occurring anecdotally from my perspective, because people are getting into their first marriages or entering first marriages later in life, closer to their 30s, some as late as the 40s. And those individuals often have established careers, accumulated wealth, personal investments. And from my perspective, it leads to a stronger desire by both parties to safeguard their premarital assets, which can include business interests that they've developed. There's also a trend here where we have a lot of parental and generational influence, where parents, especially those with significant wealth, are more proactive in encouraging or even requiring prenups to protect family assets. And this trend and this change that started about a little over a decade ago really aligns with what we see as the impending 50 to 100 trillion, that's with a T, dollar wealth transfer that's going to take place over the next 20 years. This is going to be the largest intergenerational shift in U.S. history. And what prenuptial agreements have been doing now is really focusing on how to address those complex financial realities and are now no longer perceived as favoring one party, but rather two partners recognizing mutual protection, reflecting a much greater financial independence for both genders. And importantly, like the Sex and the City model, which was very much against, at least one character was against prenuptials, there was a second person in that same episode that started to create the pop culture movement or social media and financial literacy movements that have helped normalize it. And that's largely why these have now been reframed as being smart, transparent, and often empowering for the parties involved with it.
Yes, they were all having lunch, and Miranda, her AKA lawyer friend, they are and were at the time becoming very standard procedure, and they are. In terms of what they can protect, do prenups also protect future inheritance that a bride or a groom might stand to get once somebody in their family leaves them a lot of money?
Without question. The estate planning integration of prenuptial agreements have been a much larger component because it allows the parties to clarify inheritance intentions, reduce legal disputes relating to inherited assets that may be coming down the road, preserves a party's family wealth. If you look at it this way, you're getting married to your spouse, your family may have generated significant wealth long before you were even born, and it's a way for that family to protect that generational wealth. Prenuptial agreements also often complement trusts and gifting strategies for families and limited partnerships. It can define financial responsibilities going forward. It can also help protect what I call business continuity. If you imagine entrepreneurs and business owners can use these same prenups to keep ownership interests separate, to reduce risk or prevent disruption or forced liquidation of business interests in the event of a divorce. There's also a component that's also included in prenuptial agreements dealing with something that occurs on death. It's called an elective share waiver, where you're allowed now to, by waiving the elective share, it gives parties to the prenuptial agreement the ability to transfer their family's generational wealth as they see fit, rather than being told by the courts or by their spouse how their family's wealth is going to be distributed.
Prenuptial agreement is a legal document made up of many provisions. I would love for you to describe and explain what a provision is and what are the 4 things they must say to make a prenuptial agreement enforceable.
Well, a provision is a specific clause or section in a contract that lays out an agreed-upon term, rule, or obligation between the parties. A prenuptial agreement is largely a contract between the parties, but it is also something that we utilize to define obligations to the parties during a marriage or a marital relationship, as well as obligations between the parties either on dissolution, which would be a divorce, or upon death of the parties. And often the provisions within the agreement deal with very particular issues. Sometimes they deal with specific ownership of premarital assets, how there'll be provisions that divide or deal with the division of property or debt on divorce. There will be provisions that often deal with spousal support and maintenance, also commonly referred to as alimony. There will be provisions that deal with inheritance rights. There may be provisions that deal with future income or business interests. And the way I always explain it to clients is think of provisions as really building blocks of the prenup. Each one spells out who gets what, under what circumstances, and how things will be handled in the future. Now, as to the real essential elements for a prenup to be enforceable, while the specific requirements do vary by state, generally, there are 4 key conditions that must be met for a prenuptial agreement to hold up legally. The first is easy: voluntary execution. Both parties must sign the agreement freely, voluntarily, without coercion, duress, or undue pressure. One of the common examples of somebody who might be signing a prenuptial agreement under duress is somebody who's presented with a prenuptial agreement literally at the church or religious center right before a wedding. That puts the person in a position where they can later argue that they weren't of a sound mind when they executed it. The second is that the parties have to engage in full and fair financial disclosure. Now, some states vary on how detailed this disclosure needs to be, but generally you have to disclose your income, assets, debts, and financial obligations to the other party before signing it. And that's because the agreements themselves often contain waivers or limitations on rights, and the courts will look at the agreement and say, well, if you didn't have full and fair disclosure, how can somebody make an informed decision as to what rights they're waiving? And a failure to disclose material information can often make an agreement unenforceable and effectively void before it's even been signed or even been executed. The next is a concept of fairness, reasonableness, unconscionability. Every state looks at this a little bit differently, but the idea behind it is, was the agreement fair at the time or equitable at the time of the execution? Not whether it's equal but whether it was reasonable given both parties' situations. Now, some states look at an agreement only at the time of execution, and some states look at the agreement both at the time of execution and whether it is also unconscionable at the time of enforcement. Each state's a little bit different on that treatment. We call them one-look states versus two-look states. And then the final part is that the agreement has to be in writing with parties having a right to independent counsel. It is very important that each party have the ability and the opportunity to consult with independent legal counsel. That means the lawyer who drafted it for one party is not the lawyer representing the other party. The other party has an opportunity to go meet with other counsel to understand the agreements that are contained in there. Now, having the separate attorney is not necessarily mandatory. Some states are different on that, but it is definitely strongly recommended, and it is often very crucial to enforceability.
Actress Sofia Vergara, who many people remember from Modern Family, and her ex-fiancé Nick Loeb were embroiled in what some called an embryo divorce over 2 frozen embryos they created in 2013 via IVF. For couples who are getting married and dreaming of having a family, can they put a provision in a prenup that addresses embryos?
The short answer is yes. In fact, in all of my prenuptial agreements at this point in time, one of the first conversations I have with the party that I'm representing is whether or not the parties have any type of reproductive materials, IVF, egg sperm freezing, other assisted reproduction technologies. And the reason behind this, and including this discussion and including provisions in an agreement if it does exist, is because courts are very faced with complex and emotional disputes over the control and use of embryos after a relationship ends. Having a clear, well-written agreement in advance helps prevent painful, expensive litigation later. In fact, it's a very legal gray area. Some states treat this type of material as mere property, that if the parties cannot agree with it, it's destroyed. Other states consider it almost a begin of life type of concept, and it has a very different legal, level of complexities to it. So from a prenuptial agreement, having a very well-written, and it's not just on reproductive materials, but on all issues, having a very well-written, detailed agreement that outlines the rights, the obligations to the parties is extremely important. From my perspective on the reproductive materials and the other issues, the best practices are to make sure that you use clear language in a prenuptial agreement. You coordinate with your client, the adverse counsel, to address whatever the issues are between the parties, and make sure that you give the parties sufficient time that after they've exchanged the necessary information, that when they're signing the agreement, they understand the rights and obligations that are outlined therein. Prenuptial agreements today have largely turned into a much more financially savvy and necessary document when it comes to family generational wealth planning, as well as addressing some of the very complex issues that families are faced with if the marriage either ends by divorce or through death.
Sean, for people who want to get in touch with you and learn more, how do they do that?
My name is Sean Smith. I can be reached at 973-364-5216. You can also learn more about me at www.bracheichler.com.
When life takes an unexpected turn, whether it's marriage, divorce, custody issues, or planning for the future, you need more than a lawyer. You need a team that understands the emotional weight behind every legal decision. That's why so many families turn to Brach Eichler. Their experienced attorneys combine deep legal knowledge with compassion and strategy, guiding clients through sensitive situations with clarity and confidence. Whether you're facing divorce, child custody, support, prenups, post-judgment modifications, or complex asset division, Brach Eichler brings top-tier talent from across the firm. From estate planning and tax to business and real estate, they provide comprehensive, cost-conscious solutions tailored to your unique situation. With offices in Roseland, New Jersey, New York City, and West Palm Beach, Florida, Brach Eichler is ready to help wherever life takes you. Proven results, personalized strategy, unmatched integrity. Visit BrachEichler.com to learn more about their family law services or to schedule a confidential consultation. BrachEichler.com. That's BrachEichler.com. BrachEichler.com.
This is intended to provide general information, not legal advice. Please contact Sean if you need specific legal advice. Results may vary depending on your particular facts and legal circumstances.